Hello and welcome to Friday Live. I am your host, Strata lawyer Amanda Farmer. It is Friday. We are here live for a bit of a wrap up on what's been going on in Strata this week. We're going out live to the Your Strata Property Facebook page. We're also on YouTube. We are on LinkedIn, wherever you're coming in from, however you're watching us, whether it is live, whether you're catching the replay. I always love to see your hellos and to know that you are here. So feel free to give me a hello in the comments on any one of those platforms. I hope you've had a fantastic week in Strata. I certainly have. It's been a busy week. I've been preparing to take a little bit of time off next week. So I'll tell you a bit about that at the end of today's chat, but I got some time away next week. And whenever we're going to take a week off, a few days off, if we say we're taking that time off, it just means that the week before, the days before you go away, you're doing double the amount of work to fit it all in. So you can imagine that's a little bit of what my week has been like. And yeah, not in my usual space. I'm not home today. I've sort of commenced the first part of my travels. I am in Sydney and I've just tucked myself away into a corner here, literally a corner, I think you could probably tell, of the house where I am staying to get some quiet to be here and talk Strata with you. A couple of things that I want to cover in particular today. We had a podcast episode out this week. That one just dropped yesterday. I think we pressed publish on that one, episode number 457. I am going to be talking a little bit about that one because maybe what I've shared has been a little bit controversial. Maybe there's a couple of points, opinions that I've shared in that podcast episode that you might not agree with. I've heard from a couple of you letting me know that don't necessarily agree with that, Amanda. So I do want to tackle that one here with you. And I've certainly heard from many of you, owners and managers, saying, yes, Amanda, yes, thank you. Really great summary of that topic that was covered in the podcast. Thank you for sharing that one. So we're going to get into this week's podcast episode. And as I often like to do on a Friday, and I know you love, I have a case. I have a case for you. If you're receiving my emails, you would have got a heads up about that one just this week. Just this week, the Tribunal has delivered a decision here in New South Wales about a bylaw that was challenged by an owner. The owner has been successful. The bylaw has been declared invalid. It's an important bylaw, especially for our community, for those in our circles who may have this bylaw on the books or maybe thinking about putting one of these bylaws in place. This is a case that you need to read, need to know about, and I've got the summary, the takeaways, and the action steps for you today arising from that case. So that is where we're going to spend most of our time here today. I already see those hellos coming in. Hey, Nicole, how you doing? Jan is giving me a happy Friday. Good to see you, Jan. Suzanne is loving the new hairdo. You know what, Suzanne? I love it. I love the compliments. I'll totally take it. It's often not new hair. I'm actually going to the hairdresser tomorrow because it's been a little while. It's just a different way of doing it. Sometimes when we have a day where the water and the products are agreeing with us, we can have the hair down like this. Other times when it's not, it goes all the way back. So thank you for your compliments, and I'm very happy to have a hairdresser and a hairstyle that allows me to switch it up for you guys. Hey, Sue. Hey, Sean. Suzanne is here. Sean O is here. We got two Seans. Let's hang out for the Sean trifecta and see if Sean B is going to be joining us today. All right, well, let's jump on into it. I'm seeing a podcast episode that's just popped into the chat here. That's not this week's episode, so I will just ask Rach to pull that one back out, and Rach, just check that you're on today's sheet there, and we will get this week's podcast episode posted into our chat here so that you can check it out. If you haven't yet, we are up to podcast episode number 455. 457, in fact, was this week. And I thought I'd bring this particular topic to the pod because, as I often say at the top of these solo episodes, these are the questions that I have been getting. I want to come to the podcast with the answers that you need. And this week was all about, when are owners financial? When are owners unfinancial? What is the impact of not paying your levies or not paying your levies on time? And I wanted to bust a few myths. It's a question that comes up a fair bit in our members Q&A forum. We've got strata managers in there. We've got owners in there. We've got owners saying my strata manager didn't let me vote. And as far as I'm concerned, they should have. I believe my levies are paid up to date. We have strata managers who say, Amanda, was I right in allowing this person to vote? I've been told by an owner that I shouldn't have. And it's complex. If you've had a listen to the episode, you may realize just how complex it is. I know we've got a few strata managers tuning in now who may agree with me and let me know that it's a complex area. I know when I started unpacking it for the pod, there were a lot of layers to this one. So I do appreciate your comments that are coming through saying thank you, letting me know that it was interesting, letting me know that it was useful. There are a few comments over there on the website where we publish the podcast. And I wanted to give a little bit of time to Alex's comment in particular, because Alex put in the time to listen and to draft and to post a really detailed and I think really helpful comment under the app. So you can, when we get that link here in the comments, I think it's there now. Great. Thank you, Rach. Episode 457. Head over and have a look and you can read through Alex's comment there. What I'm going to do for you now is just give you the bit of a summary of what Alex had to share. Alex is a longtime secretary of a 131 lot building, and Alex wanted to share 4 things with me. First of all, Alex says that most of the senior strata managers have no idea that in the situation where a levy due date falls between the date of the meeting notice and the date of the meeting, a lot owner is actually financial and can vote, even if that levy hasn't been paid. So you'll hear me labor this a fair bit in the podcast episode. It's all about what levies were owing as at the date of the meeting notice, not the levies owing at the date of the meeting. And Alex's experience is that a lot of strata managers are not aware of that. So in such cases, Alex has explained to the strata manager how important it is to get a snapshot of the levy position and what levies are due and owing as at the date of the meeting notice, and then to also get that updated snapshot right before the meeting, as I say in the podcast, to be able to check who has paid the levies that were due and owing as at the date of the meeting notice, and making sure that we're not calling anybody unfinancial when we shouldn't be. So as Alex says in his comment, and noting what I said in the podcast, if a general meeting closely follows a levy due date, many lot owners would appear to be unfinancial when in fact they are not, because those levies were not due as at the date of the meeting. Great point. Thank you for sharing that one, Alex, and letting me know that your experience on the ground is indeed what I have been hearing from others in this area. Alex says that what I missed in the podcast was to mention what Alex calls few cents in arrears syndrome. So sometimes coming into an AGM and registering at the beginning of the meeting, lot owners are looking at the list that the strata manager might provide to them and seeing that they're just a few cents in arrears, which technically can make them unfinancial. And that can happen where owners are paying exactly the amount that is shown on their levy notice, but they're not picking up that they are a few days overdue and that interest has accrued. Maybe just a few days worth of interest. It could be just a few dollars, a few cents here and there. And indeed, if they're paying right on the due date and it takes a day or two for that money to clear, the owner's corporation systems, the strata manager's systems can apply interest without the owner realizing or intending that there be interest charged. So that's a bit of a warning there. If you're paying your levies right on that, I've said in the podcast, you've got a month, and this is all New South Wales legislation. You've got a month to pay, a grace period, we might call it, before interest starts accruing. Some owners think money's better off in my account than in the owner's corporation's account, depending on what your owner's corporation's needs are, and leaving it until the end of that 30 days to pay. Make sure that you're aware. If it takes a couple of days to clear, then there might be a little bit of interest that has accrued that could make you unfinancial at the next meeting. So Alex is suggesting that perhaps an owner pays a couple of percentage points above the figure on the bill, which would leave you with a little bit extra and cover you off in case of a few cents interest that might have accrued. Now, Alex has said, finally, Amanda, I would disagree with you that a payment plan makes a lot owner clean of debt, were Alex's words, not my words in the podcast episode. But a payment plan, I have said in the podcast episode, I think if an owner is on a payment plan, then they can still be financial at a meeting, even though technically they're behind on their levies, they've needed a payment plan. I've said I don't think that fact of the payment plan necessarily makes an owner financial. You need to look at the terms of the payment plan, and a well-drafted payment plan will make clear whether or not it's intended that a lot owner be financial. And I want to focus on this for a little bit because Alex is not the only one who has challenged this position. There is a member in our online community, Strata manager, I believe, who is debating me on this one at the moment. So look, I decided to act like a lawyer, put my lawyer hat on and do a little bit of research on this. So Alex is telling me, along with others, that they don't agree with me that an owner who's on a payment plan could ever be financial. And let me tell you a little bit about Alex's reasoning. Alex is saying a payment plan doesn't change the levy due dates for that person. Levy due dates are set at an AGM by the owners corporation, by all those present and voting. They can't be varied by committee for certain individuals based on the amount of crocodile tears that those individuals may shed, Alex's words. A payment plan does not cancel interest. I agree with that, Alex. Absolutely. If you're going to be charging interest under a payment plan, you need to make sure that your payment plan says that, and you absolutely can do that. There's room for that in the regulation, that payment plans can contain interest, and I think that they should. Alex says it doesn't make a levy non-payer miraculously good and financial if they're on a payment plan. What it does is it just temporarily stops an arrears collection bulldozer. It gives breathing space to a struggling owner. Once the payment plan is breached, the bulldozer kicks back into gear, but the owner is always unfinancial until the debt is extinguished in full. So that is Alex's view. Having a look over here at the comments, Luke saying this is such a simple matter. Don't know if you're being sarcastic there, Luke, or maybe you've got a very fixed and firm view like Alex does about whether or not an owner who's on a payment plan is unfinancial. Sean is saying, I'm with Alex. I think the monies are overdue. Sean is also saying interest usually continues to accrue with payment plans. Yep, I agree with that, Sean, but I do recommend that you make that clear in your payment plans. All right, so I told you that I decided to, for a change, act like a lawyer, do some research here, and bring to you, once again, my view that those who are on a payment plan, I believe, can be financial. And even though you're on a payment plan, it doesn't mean that you are an unfinancial owner. That's the view I've expressed in the member forum. It is the view that I've expressed in the podcast. I've taken on board what I've heard from a few of you so far, and that view has not changed. Let me tell you why. I've gone back to have a look at the definition of unfinancial owner. This is in Section 4 in the Strata Schemes Management Act. An unfinancial owner means an owner of a lot in a strata scheme who has not paid all contributions levied on the owner that are due and payable. Contributions levied on the owner that are due and payable. These words, due and payable, are really important. They have meaning and they have a legal meaning. I did a little bit of research on the words due and payable and what they mean when they are used in contracts, when they are used in the law, and I found a case for you. This is a Western Australian Court of Appeal case. It's called CBP, I'll say that again, CPB Contractors and JKC Australia. It is a reported case. We've got the Austlii link here for you, and we'll pop that in if you want to go and have a look at it. But no need to read the whole thing. It is a payment dispute between a couple of construction contractors. But it is the case that if you go and do some research about what do these words due and payable, when are amounts due and payable, when is a debt due and payable, when are levies due and payable, it takes a close look at what those words mean. Have a look in particular at paragraph 122 if you're going to go and have a look at this case. And what it essentially says is that when we use the words due and payable in a legal context, due means one thing and payable means another. Something can be due, but it is not necessarily payable. We have to give both of those words something to do. And that's how we interpret legislation. We look at all the words and we say, well, those two words, due and payable, are there for a reason. Otherwise, it would say due. So I'm interested in the word payable because if we look at due, this Court of Appeal case in Western Australia tells us that due in a legal context means any sum that a person is legally liable to pay, irrespective of whether the time for payment has arrived. So your levies might be due if you're on a payment plan, but are they payable? I say they are payable in accordance with when the payment plan says they are payable. They're not payable in accordance with when the general meeting said that they are payable. So I hear you when you say the levy due dates are set by the general meeting. That's when the levies are due, but they are not payable until you are required to pay them under the terms of the payment plan. So that means that you are not unfinancial. You don't fall into that definition of unfinancial owner. So this case goes on to say that a debt may be said to be payable if it is not only due in the sense that it is owed, but it is presently payable in that the time for payment has arrived and an action could be maintained in respect of it. That means you could be sued if you don't pay it on time. Now, if you've entered into a payment plan, those levies are not payable until the payment plan says they are payable. And you can't be sued by an owners corporation for unpaid levies if you're on a payment plan and you are complying with that payment plan, if you're paying your levies in accordance with what's been agreed under the payment plan. So what do you think, guys? I'm standing up and saying I'm fully convinced by myself here. But there are many lawyers out there for a reason. There are always different opinions. I would love to hear what your opinions are, having heard that we have a Court of Appeal case telling us what the words due and payable mean. We have the same words in our strata legislation. What is it that makes an owner unfinancial? It's when they haven't paid their levies, when they are due and payable. And in my view, levies under a payment plan are not payable until the payment plan says they are payable. So I think we can make owners financial under payment plans. But as you've said, as you heard, and will hear when you tune into the podcast, I also say that it's important to make that really clear in the drafting of your payment plan that that is your intention. And I think in my template payment plan that's available for free to our members, we have clauses in there saying that it's not the intention of this payment plan to make an owner unfinancial. Indeed, they, however, need to keep up with those payments. And interest absolutely can, and I think should, continue to accrue under a payment plan. Make sure you've got those clauses in there too. So Western Australian case there for you. I don't see that one popping into the comments yet, Rach. So if we could get that Western Australian case here into the comments for our viewers, for those legal eagles who want to go and check that out. I've said paragraph 122 is a good one to look at, but of course you're welcome to go and read that full case. Let me know your thoughts. We might post that one, team, in response to Alex's comment as well, in case he's not, he or she, I think, is not tuning in here today. And Alex can let us know their thoughts on that one as well. All right. So look, I said I'd like to bring you a case on Friday. I am bringing you two cases here today, and we're moving on to our second case that those of you who read and received and got excited by my email today may be here to hear more about. There's been a bylaw invalidated by the New South Wales Tribunal just this week. It was Monday that this decision was handed down after a hearing, which I think took place in about March this year. This is what I'm calling the Cantwell decision, Cantwell and the owners of Strata Plan 2056. It is not a reported case. one of those tribunal cases that is sadly unreported, but I got a copy of it for you, and I am happy to share that copy. We have a link coming here for you in our chat. Many thanks to our friends at Kieran Benson Lawyers for sharing this one. They did indeed act for the successful applicant in this case. And Matthew Lowe and Alison Benson at Kieran Benson reached out to me. They've reached out to me before the decision came down, knowing that communications bylaws is something that I have spoken about previously and is something that our members are able to access, a template communications bylaw inside my own template library. So knowing that this is something that I talked about, they let me know that this decision was pending and that it might be of interest. Might be of interest to me and to you when it came down. So when it came out on Monday, they each kindly flicked me a copy of that, and I am able to share that with you. So I know I've just seen the note from the team letting me know that Rach is just having trouble posting those links. So thank you, Rochelle, for taking over there. Those are coming on through. Okay, this case is going to be relevant to you. If you have a communications bylaw in place, the communications bylaw you have in place could be successfully challenged on the same grounds and for the same reasons that the applicant in the Kentwell case challenged their communications bylaw. And indeed, if you want to create a communications bylaw, then this case is going to help you to get it right. I have certainly updated my template communications bylaw to reflect the decision, this particular decision. Members, you have access to that for free. It is already updated there in the library. Non-members, if you don't already have a communications bylaw in place, you want to have a look at this, you can purchase this as well. I'm going to come back to how you get access to each of those. If you have no idea what I'm talking about, Amanda, what is this word communications bylaw? Why do you keep saying this? What does this mean? What does a communications bylaw do? Then let's get into the Kentwell case, because I'm going to walk you through what happened in the case, what was challenged and why. And that's going to give you an idea of why some buildings, maybe yours, are putting communications bylaws in place. All right, so I'm just working off one screen rather than my usual two today. So I am just going to share with you here the decision. Hopefully that's coming up. Rochelle will butt in and let me know. You're more than welcome, Rochelle, to butt in, let me know if there's any issue with the sharing. This is Kentwell and the owners of Strata Plan 2056. As I said, these orders were handed down the 14th of July. That was just Monday. This was a hearing that happened in March. You know, I always have a look at the hearing dates and then the dates of the orders. It gives you an idea of how long you might be waiting. March, April, May, June, July. Nearly 4 months waiting for a decision on this one. As I like to do, I have highlighted some relevant parts of this for you, and I will make sure that our highlighted copy goes into our members forum so our members can refer to the highlights. As I said, those acting for the successful applicant, in this case, Kieran Benson Lawyers, and the respondent. Bear in mind, the respondent was the Owners Corporation. Respondent was represented, looks like, by a committee member, perhaps a self-represented, so somebody from the Owners Corporation there representing the Strata plan. All right, so this is a dispute arising in the context of the respondent, the Owners Corporation, having put in place Special Bylaw 31 to deal with what it refers to as excessive and nuisance communications, primarily emails, sent by the applicants to members of the Strata committee and the Strata manager of the Strata scheme. Okay, so a bylaw is in place to deal with excessive and nuisance communications. Now, there's a reason why I have one of these templates in my library. It's because over time, I've heard from many of you, committee members, Strata managers, telling me, Amanda, we really need a way of dealing with this, dealing with a deluge of emails, sometimes phone calls that might be abusive phone calls, that might be inappropriate phone calls, excessively repetitive. We're going to get into some of the terminology that's used in these types of bylaws. Can we regulate this behavior, Amanda? I have always said, yes, I believe that you can. I believe you can regulate this behavior by way of bylaw. And it's something since about 2015. Not that early, 2019, I'm going to say. I have been talking about in my webinars how you can use bylaws to help combat bad behavior in strata schemes. Communication bylaw has always been top of my list of recommendations. When I hear from you, as more and more people are using emails over the years, we are really struggling with difficult communicators. Let's put it that way. So a number of buildings have put in place these bylaws to deal with what this plan was apparently trying to deal with, excessive and nuisance communications. Moving on down, it's a 6-lot strata scheme. So this is a little community, tight-knit perhaps, community, and the applicants own lot 6 in the scheme. The special bylaw was headed Communication Protocol. It was made in June last year. And this is interesting. A special resolution unanimously passed at an EGM. And the minutes record that all 6 lots in the strata scheme, including the applicants, attended that EGM. So the applicants who less than a year later, are challenging the validity of this bylaw actually attended the AGM and voted in favour of the bylaw. Now, this was raised in the proceedings. The tribunal did deal with this question of, does that change things? We'll get to that. We will find out whether the tribunal took that into account at all, that this was a unanimous decision with all lot owners attending the meeting to put this bylaw in place, including the applicants. So here's the minutes. Everyone voted in favour there of the bylaw. The purpose of the bylaw is to establish a procedure and standard for senders and recipients to follow when sending or receiving communications, to ensure that all communications are handled efficiently and to minimise the impact on the owners corporation and strata management resources. That's in the bylaw. Communication from a sender to a recipient, says the bylaw, must at all times be polite, respectful, reasonable, appropriate, constructive, and succinct. It must not be abusive, offensive, threatening, unnecessarily voluminous or lengthy, contain false statements or allegations, unsupported by evidence or specific detail, be defamatory, be aggressive, be unnecessarily repetitive, be rude or insulting, be a nuisance, or contain personal insults or invective. So these are the rules about communications in this bylaw, and that this community wanted to adopt. Everyone in this community at the stage of adoption wanted to adopt. Now, the bylaw goes on to say that in the event a recipient reasonably considers that a communication does not comply with the terms of Special Bylaw 31, then the recipient may, in their discretion, disregard or not respond to the communication, or issue to the sender a response notifying the sender of their concern. Now, the tribunal had a bit to say about this particular section of the bylaw. We're going to get to that one. The sender's options: if the sender's not satisfied that their communication has been properly responded to by a recipient, rather than resending their communication, they're required to submit a motion for inclusion on the agenda, I think it's a typo there, on the agenda of the next general meeting of the Owners Corporation, proposing action on the issue that is the subject of the communication. So there's a regime there for how those who don't believe their communication's been properly responded to, they can take some next steps. Interesting clause at the end here. I hadn't seen this one before, not one that's included in my template. Access to members of the Strata Committee on body corporate matters can only be made by email to the Strata Committee group email distribution list or via the Strata manager. So that perhaps sounds to me like this Strata Committee was a little bit fed up with, or wanted to stop the practice of individual owners or residents contacting Strata Committee members directly or separately. So this bylaw attempted to put in place that rule. At an EGM held in October, there was a motion put forward by the applicants for the repeal of the bylaw, and that was defeated. Just want to be drawing attention to that particular step. It's something that I do recommend if you're an owner who wants to challenge the validity of a bylaw, it's usually a good idea to try and get a motion on a general meeting agenda first of all, proposing the repeal of that bylaw. If you go straight to the tribunal, I've seen this happen before. The tribunal says, okay, yep, I can see you're an applicant, you're an owner, you're entitled to vote on the bylaw, you have standing to bring these proceedings, but have you asked the owners corporation? Have you asked your fellow owners if they're happy with the bylaw? Maybe if you just put it to a meeting, then they'll agree and the bylaw will be amended or the bylaw will be repealed, whatever it is that you're asking the owners corporation to do. The tribunal may then exercise its discretion to do nothing about the bylaw and to leave it in place because you haven't yet taken that step of going to a meeting. So applicants knew what they were doing here by the looks of it. Remember, unrepresented here in the tribunal did a good job, knew that they should put this to the meeting first, but the meeting defeated that proposal to repeal the bylaw. So bylaw still in place. Applicants proceed to the tribunal. Tribunal says that the Strata Schemes Management Act gives an owners corporation a wide power to make bylaws in relation to the management, administration, control, use or enjoyment of lots, all the common property and lots of a strata scheme. So that's how we end up with sometimes some wildly creative bylaws. You may have read a recent media article where I was quoted saying, I saw a bylaw that said no more than 10 fish in a tank. That's the limit on fish in that particular building. Yeah, it's possible for buildings to make bylaws about all sorts of things as long as those bylaws are in relation to the management, administration, control, use or enjoyment of lots or the common property and lots of a strata scheme. Leading case at the moment on that question, Cooper Court of Appeal case in New South Wales, and particularly when we're looking at whether bylaws are harsh, unconscionable or oppressive, we're going to be looking at the principles established in the Cooper case. All right, so the owners corporation in this case says that this special bylaw became necessary because of what it referred to as an excessive number of emails sent by the applicants to members of the Strata Committee and the Strata Manager, and they felt they needed a bylaw to the effect of this special bylaw to be able to stop the type of communications complained about. Scrolling on down, you'll see a lot of these decisions will recount the law, the relevant legislation. You can absolutely read that in your own time. Quite an easy read here, this decision. And I think it's a good decision. I think it's a thorough decision. I like how the member has walked through the reasons why this decision has been made. But here's the crux of it. Having regard to the authorities, so having regard to the precedent cases that are binding on the tribunal, the owners corporation's subjective intention to put in place a process to deal with what it viewed as excessive and unnecessary emails from the applicants to the Strata Committee is not relevant to a consideration of proper construction of the bylaw. So remember, the bylaw had a clause in there that talked about why we are putting in place a communication protocol or why we want to have a communications bylaw. What the tribunal here is saying that that's the owners corporation's subjective intention. Why it's putting in place this bylaw is not really relevant. I'm not going to turn my mind to that fact that the owners corporation was trying to deal with a problem that it was experiencing here in the community. What is also not relevant is the applicant's reasoning as to why they voted in favour of the bylaw or their concerns as to how it may operate in the future. So that the applicant voted in favour or why they might have voted in favour a year ago and now they're not happy with it, none of that's relevant. So what I'm reading between the lines here is that there was a bit of argument in the tribunal and a bit of evidence perhaps about how all of this came about, why we needed the bylaw, why the owners corporation thinks the bylaw is a good idea and why the applicants voted in favour of the bylaw 12 months ago. Tribunal is just saying, no, I don't need to look at that. I'm just going to look at the terms of this particular bylaw as it operates now and what it means on its face now. Tribunal also says, I have some sympathy for the respondent, for the owners corporation, having regard to the authorities. I have some sympathy that is on the question that the applicants voted in favour. So while I have sympathy for the respondent, the fact that the bylaw was approved at the June meeting by all lot owners, including the applicants, it's not relevant to a consideration of whether the bylaw is harsh, oppressive, or unconscionable. But it might be relevant to the question of discretion. So as I said earlier, the tribunal in New South Wales, even though it may make a finding about a bylaw being harsh, unconscionable, or oppressive, and it may be open to the tribunal to declare the bylaw invalid, because of that, it doesn't have to. It has discretion. So the tribunal can say, yeah, bylaw on its face, it's harsh, but for some other reasons, I'm not going to declare it invalid. And what the tribunal member here is saying, in certain circumstances, not this one, as it turns out, but in certain circumstances, the fact that everyone voted in favor of this, every owner voted in favor of this, including the applicants, that could be relevant, maybe in another case, to the exercise of discretion. And it might be that a tribunal, considering a different case, different bylaw, will exercise their discretion not to invalidate the bylaw if the applicants voted in favor of it. Okay, so what else did the tribunal say about the bylaw? For the reasons set out below, I am satisfied that the bylaw is harsh, uncomfortable, unconscionable, I think that word is, an uncomfortable bylaw, I like that, or oppressive for the following reasons. And these reasons are quite confined, I'm going to say. There are a few clauses that were pulled out of the bylaw where the tribunal member said, I don't really like the way that that operates in practice. These are the clauses, or these are the parts of the bylaw that the tribunal didn't like. The bylaw allows, for example, the strata manager or the strata committee at its discretion to disregard or not respond to a communication, for instance, an email from an owner. There is no delineation between, for instance, whether a communication is in respect of an urgent matter. So there may be a communication about an urgent matter, and under this bylaw, technically, it is open to a strata manager or strata committee to not respond at all if they believe, if they unilaterally and subjectively believe that the communication does not comply with the communication protocol. So remember those protocols about shouldn't be abusive, shouldn't be insulting, shouldn't have invective, shouldn't be unduly repetitive. If the recipient forms the subjective intention, a subjective belief that this communication suffers from those defects, then they don't have to respond. They can disregard that communication. And that means that the sender of the communication could be left not knowing if a view is held that the communication did not comply with the protocol, and if so, why? But the sender can't resend the communication. Remember, the bylaw says that if they're not happy with the response that they get from the recipient, or they don't get a response at all, then they need to prepare a motion for the next meeting of the owners corporation, whenever that may be. And we know that could well be some time away, and that single owner may not have the opportunity to issue a qualified request and force on a general meeting. So they may be waiting for some time. And the difficulty then arises because the issue could be urgent, but the communication cannot be resent. Tribunal says the effect of such an operation is that an owner with no intention not to be polite, reasonable, or respectful, appropriate, constructive, or succinct, communicates with the strata manager or owners corporation in respect of a matter that may be of some urgency, but having not received a reply, is left with no option but to prepare a motion for the next general meeting, whenever that may be, not even knowing why their communication has not been responded to. So the tribunal says this is a bylaw that forces an owner in such a situation to prepare a motion and, if relevant, obtain quotes. So that is in the bylaw, that if the owner is wanting the owners corporation to do something for which the owners corporation may need to spend some money, then the owner can obtain quotes and submit those as part of their general meeting motion. But that's in the absence of any understanding as to whether there's any issue with the substance of what is sought in the communication that might not have been responded to, or whether the lack of response is because the recipient believes the communication is not polite or succinct or did not comply with standard business protocol. So in short, tribunal says, my finding that the bylaw is harsh, oppressive, or unconscionable is not because it seeks to regulate how, for example, owners, the strata manager, and the strata committee are to communicate with each other in respect of matters relevant to the strata scheme. That's important. Those are important words there. What that tells us is that the inverse is perhaps true. If we do have a bylaw that does regulate how owners, the strata manager, and the strata committee are to communicate with each other, then that bylaw is not necessarily harsh, oppressive, or unconscionable just because it does those things. It's about how. how we do those things. So here I see the tribunal saying, yeah, we can regulate how people communicate with each other, and we can use a bylaw to do that, but we need to be very careful about how that bylaw actually operates in practice. This bylaw, the way that it operates, in the event the recipient takes a reasonable but possibly arbitrary view without informing the sender of that view, that a communication was, for instance, not polite, succinct, or in accordance with standard business protocol, then the sender is never going to know. They're not going to know that that was the problem. So it follows that there's likely to be circumstances where the bylaw may operate fairly, and subject to amendments, it may operate in a way that is not harsh, unconscionable, or oppressive. But as noted above, it is not the tribunal's role to rewrite the bylaw. And the fact that it may, in some circumstance, operate fairly cannot save it from invalidity. Again, really important takeaway here. This is a situation where a bylaw of this type could operate in a way that is not harsh, unconscionable, or oppressive. There may be some amendments that can be made. There may be some rewriting that can be done to bring the bylaw to the standard that it needs to be. Tribunal's not going to do that, but is leaving room for that to be done. Okay. Now, finally, an important point here. If you think back to I mentioned to you the broad bylaw making power that we have, and how our bylaws can cover a whole range of things as long as they are in relation to the management, administration, control, use, and enjoyment of lots or the common property or lots in the strata scheme. One alternative argument that the applicants put forward is that this is a bylaw that falls foul of that. It is not a bylaw that seeks to regulate the management, administration, control, use, or enjoyment of lots. It's a bylaw that tries to do something else or do something more than that. The tribunal expressly didn't deal with that argument because they didn't have to, but does make a comment here that it seems to me, says the tribunal member, on a provisional view that the making of a bylaw to govern communications, for instance, between owners, strata committee, strata manager, would be in relation to the management, administration, control, use, or enjoyment of lots or the common property. So it sounds like this tribunal member, at least, believes that a communications bylaw as a concept is something that there is room for an owners corporation to make and to implement within the provisions of the Strata Schemes Management Act. Expressly didn't have to deal with that because tribunal member was satisfied that the bylaw and its terms was otherwise harsh, unconscionable, or oppressive, and declared that it is invalid. All right. So that is the Kentwell decision. Let me know your thoughts. I'm going to head over to those comments and just see if you have some views there. I'm just conscious of the sun setting in my face here now. Sorry about that. But this is the thing. If you have one of these communications bylaws in place, you will know if you have one. It might be called communications bylaw. It might be called communications protocol, as it was in this particular case. You need to go and have a look at it. It may look very similar to the bylaw that was challenged in this case. Indeed, my template that was inside our library, our templates library, was very similar. Not the same, not identical, but very similar to at least those clauses that I could see here in the decision, which is a big part of the reason why I wanted to bring this to you and bring it to you quickly. And it is something that we've been talking about inside our member forum as well. Absolutely, I have updated my template communications bylaw to reflect the findings in this decision. There are a few clauses that the tribunal had focused on there in that decision that I have now reviewed and have amended to make sure that they are in line with this decision and they are less likely to, I'm going to say, suffer from successful challenge in the tribunal. Members, you get this update absolutely for free. We have a link here to our updated members only communications bylaw template. If you have this bylaw in place, what I'm going to do to make it easy for you members is in our forum, we'll post a new thread that has the marked up, highlighted copy of this case that has the updated communications bylaw, and I'm going to give you the markup to show you exactly what the few clauses are that have been amended and how they've been amended. Because if you are putting a motion forward to amend your own communications bylaw, and if you are working off the one that is in my templates library, you can put a motion forward just showing what those amendments are. So you'll have the old version to compare to the new version, and you can see what it is that's been changed and form your own views. Form your own views about whether you think those changes deal with the criticisms of the tribunal. And indeed, as always, what I say here on Friday Live, what I say in our member forum is not legal advice. It is not legal advice that is specific to you and what it is that your building is going through and what your building wants to solve. So if you are looking at amending your communications bylaw, putting in place a communications bylaw, absolutely access that template and those changes, but go and get some legal advice, your own legal advice on that as well, and see what others think. We started off this chat with, there's a lot of lawyers out there. Lawyers have different views. Strata managers have different views from lawyers. Go and engage somebody who is able to give you that one-on-one legal advice. And if you want to access, if you're not a member and you want to access my communications bylaw template, it is not expensive at all to get your hands on that, perhaps as a thought starter, perhaps again to compare to what you see in the Kentwell decision and see if you might put that in place for your community or improve on that at all. We've got the link for our non-members to head over and you can purchase standalone a copy of that communications bylaw template. All right, so I know, Rochelle, you have been dealing with some link problems there in the chat. We'll swing back around and just make sure if any links are missing from our Facebook chat, that's where our links are going. If you're on LinkedIn or you're on YouTube and you're wondering where the links are, we generally don't post them across to those platforms. Facebook is our most popular platform. So you're welcome to come on over here to Facebook and follow the Your Strata property page and access all of these comments and the links. Otherwise, you can pop into my inbox at any time, amanda@yourstrataproperty.com.au, and the team will be happy to share these links directly with you. Okay, so let's see what I've got here in terms of comments and questions. Thank you, Sean. You have a good weekend as well. Karen saying, what really concerned the tribunal with this bylaw? Yeah, so Karen, in summary, it was about the sender not having to hear back from the recipient that their communication breached the communication protocol. So it was open to the recipient to disregard the communication if the recipient thought that it didn't comply with the communication protocol. So you'll see, Karen, if you have access to the updated version of the bylaw, that's the section that has been changed in the bylaw, so that the recipient now must give an initial reply, at least an initial reply, setting out the reasons why the recipient believes that the communication does not comply and giving the sender a reasonable opportunity to respond and to correct and to clarify and to amend their communication to, heat of the moment stuff. We might have some typing under the influence maybe, or some keyboard warriors out there on reflection, looking at a communication and saying, yeah, actually I might write that one separately. I'd really like the opportunity to do that. So Tribunal has said that regime, that process should be built in to the bylaw. And that's what I've done. So you'll see that in the updated version. Chris saying, I have a motion in for your old template at an AGM on Monday. Can I substitute with the new one at the AGM? Yeah, absolutely, Chris. And I'm not sure if we've been talking in the forum about this. There is a member in the forum who had a question about this, and I have strongly recommended that anyone who's putting up that old template for adoption pulls that in light of this case. And yes, if you want to substitute the new template, again, open to you to go and get legal advice on that. But if you want to substitute the new template, then that's a good idea. If you're in the forum, Chris, or if you're a member, and if we're already talking about this in the forum, you've got that conversation there for you. If you're not, then please pop any further questions about that into the forum. Okay. All right. Not sure what was happening with the system there with those links, guys, but we'll get them over to you. Chris, I'm glad that is timely. Sean's got a comment about payment plans and financial statements, section 85.7. OC can still take action to recover even if a payment plan is in place. I'll have a look at that. Sean, I think I've had turned my mind to that one before. I think I've got an answer for you, but I won't do it on the fly. I'll have a look at that and come back to you. Okay. Sean saying, I can see some of those being harsh, unreasonable, etc. Yeah, interesting. The communications bylaw that I have, I think I mentioned, has been around since at least 2019, pre-Cooper. Pre-Cooper case. Yeah, so things change. They do change. Standards change, legal concepts change, and we do have a bit more guidance now from our superior courts about what it is that would make a bylaw harsh, unconscionable, or oppressive since that communications bylaw was first put out into the world. Emily's saying they made a code of conduct on how people speak to each other. However, when the committee does understand structural engineering and how building works, they're ineffective to make decisions. Yeah, I'm sorry that you're going through that, Emily. And if that's a problem at committee level, remember, as an owner, you can always take matters up to the general meeting level, propose a motion at your next meeting and get this in front of whatever your issue is, get it in front of all of the owners and see if you can get some action that way. Some committees are frozen in their decision making and can be ineffective. Maureen saying some SCs, strata committees and strata managers don't want other owners to have any say or query what they're doing. They use communication bylaws to block other owners. Yeah, certainly not the way that that bylaw is intended to be used or the problem that that bylaw is intended to be solving. So the updated drafting requires, as I've said in response to Karen's question, requires the recipient of that communication to explain why they're not going to respond or explain why they think that the communication is in breach of the communications protocol and give that sender another opportunity to send their communication through. Sean pointing out the codes of conduct are unenforceable without a valid bylaw. Yep, fair point. Okay, excellent. I am going to leave it there for today. I know I haven't got to every comment that is there in the list, but as you know, I do come around and check up on those. Thank you so much for all of you who are here live today and who have contributed and participated. I will be out in the big wide world next week. I'm going on a hike. Some of you know I went hiking in New Zealand earlier this year. I'm going on another hike. Got the hiking bug is the word. I got distracted because I just popped into my head that my brother, who I saw last night, said to the family, Amanda's in her hiking phase. This is her hiking phase. So just so you know, guys, this is the hiking phase. Going on a hike, I'm going up to Queensland, flying to Brisbane on the weekend, then to fly into Roma. Let me know if you know Roma. And we are hiking the Carnarvon Ranges. So beautiful part of the world, as I understand it, not a place I've been to before. Group of 10 of us there. We are glamping, the way that I like to do things, and exploring the beautiful Carnarvon Ranges. If you've been there, if you've got tips for me, let me know. Maybe I can share a few photos here for you. But that's what I'm doing next week. I think reception might be a little bit patchy. So we're getting the team organized to run the show next week. And I'll look forward to letting you know how it all went, catching up here with you again in a couple of weeks' time. Have a fantastic weekend in Strata, everybody. Bye for now.